Hi everyone, welcome from Law with Dunk, the Law Guy. I'm actually the white Mighty Morphin Power Law Ranger today. I do cringe a bit myself, so I don't know what you're thinking. Some wine has helped me feel comfortable wearing this. Anyway, today, not drunk, anyway, today is day 48 of the Case a Day series journey, covering cases across criminal law, tort law, contract law, and the English legal system. Apologies for the day delay. The prep for this recording did prove to be tricky, hence the day needed for research. If you ever have a case you want me to cover, feel free to pop it in the comments section, and I'll get round to it if I can. Today, I'd like to embark on covering another aspect of mens rea, which I have come to refer to as another mens rea mechanism, which is known as the coincidence rule, and this is twofold. The coincidence rule breaks down into continuing act theory, which refers to a situation where the actus reus happens first, and then at some point during the actus reus, the defendant goes on to form the mens rea. And transaction theory, where there isn't one continuing act, but instead numerous acts or a series of acts or events, where the courts treat the acts, so multiple acts, as one transaction. And where the defendant possesses the mens rea during one of these acts, it will be deemed as being present throughout the transaction. I'll just say, I don't want this to be a lengthy recording, but when you go to the, hole in the wall ATM cash machine, you put your card in, and if you went to I don't know, a bar or a pub or whatever, and your friend was waiting for you and they went, "What took you?" You wouldn't say, "Oh, well, I put my card in the hole in the wall, and then I entered my PIN, and then I didn't want to look at my balance, but then, I picked how much money I wanted, and then, I picked a tenner, and I didn't want a receipt." You wouldn't say all that. You just said, "I needed to make a transaction, or I needed to put my card in, get some money out, pull some money out, transact, whatever." But a transaction is just obviously a more concise way of saying a series of acts. Okay. Before I move on to continuing act theory as a form of coincidence rule, and explain how it can be seen in the case of Fagan v. Metropolitan Police Commissioner 1969, I'd like to explain what I mean by a mens rea mechanism. What I mean by this, and it's something I made up really to help my students understand it, and I like it, I love it, okay, is principles such as transferred malice or the coincidence rule aren't mens rea tests like direct intent, indirect intent, recklessness, negligence, so on, okay, but more a way of moving or slotting in one of these mens rea tests, such as direct intent, indirect intent, recklessness, alongside the defendant's actus reus. They're legal principles. Coincidence rule is, it's a legal principle, it's a legal test in the sense of there's cases that promote the use of this area of law, so you could say there's legal tests, but I'm more in the sense of I don't consider coincidence rule or transferred malice as mens rea tests of acquiring what the defendant's mens rea is, like direct intent is, like subjective recklessness is, like indirect intent is. So I hope that makes sense. Now, as you're aware, as part of the criminal liability equation, for an offence to occur, there must be the actus reus and mens rea present at the same time. For example, and this is a hypothetical, so don't read into it. Let's say I did a job where I hated my boss. I love my job, okay? Love my bosses, so, okay. And let's say I came home from work one night and I was so angry that I planned a way to kill my boss. But then I arrived to work the next day, opened a door, which hit my boss in the face, and my boss staggered backwards and fell down some stairs and died. You can see here, with this hypothetical situation, that I would have possessed the mens rea the night before and the actus reus the day after. But both wouldn't be present at the same time, and so there would be no coincidence, no coming together, actus reus and the mens rea here to find me guilty of a criminal offence. However, the courts have devised ways with the various strands of the coincidence rule, which I've already touched upon, to ensure that a defendant can still be found guilty of a crime even where it might appear at first glance that the mens rea wasn't present during the actus reus. So, Why was there a coincidence of both the actus reus and the mens rea in the case of Fagan v Metropolitan Police Commissioner 1969? In this case, the defendant Fagan was approached by a police officer whilst he was sitting in his car. The police officer told Fagan to move his car, and so Fagan proceeded to reverse his car onto the police officer's foot. The officer shouted for Fagan to move his car, however, Fagan responded by swearing at the officer. He may have said, F you can wait, okay, and refused to move his vehicle and turned off the engine. Fagan was found guilty of the crime of assaulting a police officer in the execution of his duty, and Fagan appealed and tried to overturn this trial decision. Fagan tried to argue that he couldn't be found guilty of the offence he was convicted of at trial, as when he initially drove onto the police officer's foot, as this was accidental, and therefore he will have been lacking mens rea at the time of the actus reus first being committed or initiated. It was also decided that with his legal team taking issue with the term assault within the offence of assaulting a police officer in the execution of his duty, an assault could not occur via an omission, but a battery could. And even though an assault is separate to a battery, the word assault is often used by a layman to convey the meaning of a battery. So-and-so was assaulted today, when they've actually been beaten up, force applied. And therefore it was argued that Fagan's crime was the continual act of a battery, continuous actus reus, continuing act theory, when he refused to move the car after discovering that it had been parked on top of the police officer's foot, and when refusing to move his car off of the police officer's foot, despite the actus reus being continuing at this point, this would have most likely have been the actus reus of a battery being committed via an omission, i.e. the creation of a dangerous situation, and Fagan would be under a duty to minimise harm. And Fagan's refusal to remove his car would have been the formation of the mens rea of a battery partway through the actus reus here, which would have been a direct intent, Arvi Mohan, main aim, to apply unlawful force to the police officer and the police officer's foot. Thus, we have the coincidence coming together of both the actus reus and mens rea for the crime of a battery upon the police officer here, and so Fagan's trial conviction was upheld. And that's it for today. Thank you from Law with Dunk the Law Guy, and I'll see you Thursday.